Hello and welcome to this first masterclass for Busy Entrepreneurs. I am Nicola Massella. I'm from Store Partners. A little introduction about ourselves. So we are a consulting firm based in Geneva. We assist Web3 businesses to spark their ideas to life. So basically, we work with organizations that are engaged with blockchain and crypto assets to help them do what they do better. We work with some large organizations. We work also with startups. And the point of what we are doing here with Cardano is to provide some education to entrepreneurs or wannabe entrepreneurs that want to start a company or a project related to Web3 and in particular related to the Cardano ecosystem. When starting a new project, there are a lot of aspects to be taken into consideration, from legal to marketing, and our course should give you a glimpse of all these aspects. We have divided the course into several months. This first month will be the month of legal. So we have 4 master classes related to legal topics, and I'm here doing the first one. Why did we start from legal? Because maybe it's the most boring part, although in Web3 it's not really boring, but it's definitely an important one. I think it's important to get it right from the start and to have the good foundations to start your business. And today we are really speaking about the foundations and how basically to start a business in Web3, what are the aspects that we should take into consideration, and let's say how to navigate the complexities of doing business in an area that is, let's say, a bit uncertain from a regulatory perspective. So, without any further ado, let's start. Again, maybe about this first month, then the idea of the first month and the kind of like knowledge skills that you should get out of this first month are listed here. We want you to understand what are the most relevant legal issues for Web3 projects, what should be the setup for your project, what are the implications of fundraising through the issuance of a token, which is something, of course, most of our clients do. What are the contracts that are most common for Web3 businesses? You should at least have a basic understanding of how those work. And then, of course, the most, maybe not so friendly part, the part related to the risks of not complying with the laws and regulations that are applicable to your business. And also, when should you basically call a lawyer and understand from a professional what you need to do. So in this lesson, we evaluate why legal is so complex in Web3, how to define a regulatory strategy, so how to come up with one, how to choose the right corporate structure for your business, how to choose the right jurisdiction for your business, how to define a legal roadmap, so basically like how the implementation will really work, and then we analyze a couple of case studies that are common to Web3 projects. So let's start from really why legal is so complex in Web3. Sorry if I laugh, but I perceive that there is a sort of kind of a misunderstanding of this. A lot of people think that legal is very complex in Web3, and for sure it is complex to a certain extent. However, it's just really a matter of, I think, information asymmetry. I think that people like me or colleagues that work really with Web3 startups can tell you that there is nothing incredibly difficult, but you need to know the right things. Well, let's start from why there are some actual complexities when dealing with Web3 businesses. Well, basically, the point here to be understood is that most of the law is a bit old. Okay, so we have new paradigms, new business models, new ways of launching a venture, of fundraising, of really operating your organizations in a way that is kind of unprecedented. And we have to do it in a world that has not been kind of like prepared for that. The laws that we have to comply with have not been drafted considering blockchain, crypto, and Web3 and these innovative paradigms. The most disruptive innovation in blockchain is really the fact that in blockchain code is low. So, for instance, it really comes into play when you're doing a token offering and you're at your vesting schedule, and the vesting schedule is volume of the smart contract. So there, apart from whatever you write in your SAFT agreements and so on, the vesting schedule will work as it is written in the smart contract, because it's a smart contract and that regulates it. Then if you can upgrade it or not upgrade it or modify that, that's another story. But really, in a lot of situations, we could say code is low. And this is applicable also to DeFi. Of course, now, what is the legal meaning of that? How do you translate that into something that makes sense from a legal point of view? Well, that's really another story, and this is what we're speaking about here. Like, you have to find a way to either you do it yourself or you work with, meaning like you have a general counsel on your team, or you work with external professionals in order to make sure that your legal structure reflects what happens on chain, and that your legal structure is consistent with what you intend to do on chain. One thing that is important to clarify from the beginning is that in the past, in particular, I'm thinking about 2017, 2018, for people that have been in crypto for a while, there was a sort of misconception about the crypto space being outside the reach of the law, outside the reach of regulators, of law enforcement, and so on. This is not true, of course. I think that everybody now can see that. There are some crypto entrepreneurs that did some bad things that went in jail, or that are under trial. American authorities in particular are quite adamant to pursue crypto businesses that, in their view, are doing things not in the right way. So I think it's now clear a bit for everybody that the legal side needs really to be taken into consideration, and that it's not that because something is on chain, then it cannot be regulated, or the law cannot stop it. Because maybe, yes, the law cannot stop the code, but the law can stop the people because they can arrest them. So there is always an aspect to be taken into consideration, and that aspect is the legal side, of course. Now, again, why legal is so complex when it comes to Web3? Second point, lack of adequate legislation. It's true that in most jurisdictions there is not good regulations. There are not good regulations related to crypto and Web3, but this is changing. In Europe, we have MiCA regulation now, and it will come into full force by the end of this year. And this establishes quite good rules for a lot of activities to be carried out in the crypto space. Yes, it's true, as many have said, DeFi is not included, DAO are not included. Okay, a lot is not included, but at least it's a very good base that regulates the issuance of new tokens, in particular utility tokens. It regulates the activities of BASPs, CASPs, so crypto asset service providers, exchanges, custodians. It provides for certain kind of like limits that were not there in the crypto space before. For instance, you cannot do insider trading anymore on your own tokens. There are provisions against market manipulation. A lot of phenomena that we have actually seen in the market that are, of course, bad, in particular bad for the little fishes and not for the big whales that often benefit from market manipulation. But indeed, protecting the little fishes, which are the vast majority, it's beneficial to us all. So I think that's a positive step for sure. But of course, the lack of adequate legislation in many other jurisdictions, for instance, the US, creates regulatory uncertainty. And the uncertainty is really kind of like the enemy here, because you don't even know what to do. And I can say that now the space is becoming old enough that a lot of this uncertainty is going away. There are still areas of uncertainty when it comes to more innovative things. For instance, on DeFi, there are debates and there is a certain amount of uncertainty. But for instance, on the legal qualification of tokens under, let's say, European law, Swiss law, Singaporean law, there is kind of a lot of clarity about how a token qualify, what are the tokens that are financial instruments, securities, what tokens are not financial instruments, what are the rules in order to issue a token, or to have a platform that works with tokens. Then another kind of like negative point to why legal is so complex in Web3 is the adverse sentiment. And this is not really related to regulators. It's more related to other players, such as banks, financial institutions, service providers that you need to work with. Because every business needs a bank account. And there is nothing in the law preventing a bank to open an account for a crypto company. However, a lot of banks don't do that. Why? Because they don't understand the business model, because they don't have trained compliance team that do that. But most of all, I believe, because there has been a sort of adverse sentiment towards crypto. Some say that it derives from the fact that banks are afraid that these will, like the crypto space in general, will kill them. It might be, but most probably, honestly, it's the fact that they are afraid of taking new business without the proper knowledge, and in particular, new business that has so much negativity around in terms of criminal usage of crypto, money laundering, and these sort of things, which, if you look at the real data, Chainalysis and Elliptic, they publish yearly reports about this, the criminal use of crypto is quite insignificant, we could say, with respect to the vast majority of the use cases, which are, of course, legitimate. And then maybe one last point on why legal is so complex is the lack of trained professionals. We are happy because we have a lot of business. We have a lot of business also because we don't have so many competitors. There are not so many lawyers and other kind of professionals that are experts in Web3. So my advice for entrepreneurs is like always look for good ones and for people that know actually what they're doing. Now, let's go a bit more into the topic of today. And the first point here is how to define a regulatory strategy. And maybe you can even take a step back and say, why do you need a regulatory strategy? Well, you really need one when you operate in Web3, because a lot of business models in Web3, they kind of challenge existing regulations, okay? And they are sometimes in conflict with existing regulations. So there is a certain regulatory compliance risk, legal risk in operating a certain business model. And for instance, here, the most obvious example is DeFi platforms. DeFi platforms, and this is witnessed by the recent case that the SEC is going to start against Uniswap, can be seen by regulators as trading venues. Trading venues that should be subject to traditional financial regulations that should receive an authorization before they start their business, and so on and so forth. So you need to understand if your business model triggers the applicability of these kind of regulations, if to operate your business model you actually need to be authorized or not. And one very important factor that we stress with our clients is that it depends a lot. Like if you work with good lawyers from the beginning, you can shape your business model in a way that you do not need to get regulated, or that at least you can manage this. Like you can start with a version of your platform that is maybe more simple in the beginning and includes less functions. And for like to operate that, you don't need to be regulated. And then you put in your roadmap that for the version 2 of your platform, you will actually need to get a license, but you plan it ahead. And you know that you will kind of do the process in order to get to the release date of version 2 with all the necessary authorizations in place. So a regulatory strategy is actually very, very, very important for every sort of Web3 project. And maybe your project will be very simple and will not need much of a regulatory strategy. Even in that case, you should still do it, because at least you know from the very beginning, and your investors will know, and you can have kind of like peace of mind. I noticed that a decent amount of crypto entrepreneurs adopt the kind of logic, move fast, break things. And look, I have no judgment, of course. And I think that entrepreneurs that have this mentality are actually doing kind of the right thing, we could say, in terms of they need to move things forward. You should not get stuck. However, it's important that the things you break will not come back to you, will not backfire. And so you really have to manage what is the risk involved in breaking things, to keep with the same metaphor. So really, what's the point here? is to identify these legal risks, to evaluate what risk mitigation measures are available, and to pursue a cost-benefit analysis. And I want to give you a very concrete example. So you, for instance, are a Web3 game, okay? And in your game, you have a platform for the exchange of in-game items that are NFTs. So people can use your own native token as an internal currency, and they can buy and sell NFTs and trade them among each other. So here, you may have a legal risk related to anti-money laundering. Like, should you do the KYC? Should you not do the KYC? There are a lot of factors to be evaluated there in order to decide if you should or should not do that. Of course, let's say the lazy answer from a lawyer could be, yes, do it. In any case, do it. Which is fine, but it doesn't really take into consideration all the needs and let's say all the aspects that the client should take into consideration. Because of course, if you are working with game and you're doing KYC and all your other competitors are not doing the KYC, it may be detrimental to your interest to do it, because maybe people will just go to another game where they don't need the KYC, and maybe they will even be a bit bothered by the fact that your game requires them to KYC and others do not. So what is the cost benefit here in terms of what risk I'm assuming in not doing the KYC, and what is the benefit that I get from not doing the KYC, versus what is the benefit of doing the KYC versus the cost in terms of really this expense for the KYC and also the kind of impact on my business of doing the KYC instead. And long story short, I can even tell you that for a lot of Web3 games in which the price of in-game items is quite low, so the amount of transaction maybe is large, but the value of each single transaction is not particularly significant, there is not enough legal risk to justify putting in place a complex KYC process. So now, of course, it's not legal advice, by the way. It's just an example for you to understand, but it works kind of on this way. And then, of course, once you have established a sort of regulatory strategy, and we can come back to it about maybe different ones, you really have to assess the implementation. You should have a clear idea of the necessary steps to be taken, how much they will cost, how much time they will take, how much in advance you should start kind of like doing the various things that are necessary for you to implement your regulatory strategy. And last but not least, to get support. So again, support can be internal, can be external. You can have an internal general counsel. If you get some VCs that provide you also with the more tangible support and money, like you may want to use their lawyers, or at least you may want to discuss with them the possibility of having access to their lawyers, having a weekly call or a big weekly call with them. Or you reach out to an external firm and you get someone to advise. You can get them on retainer, which is usually what we suggest in terms of having someone that is always available for you. You have recurring meetings and they really kind of like check on an ongoing basis that you remain compliant. Or maybe when you are a bit like cash-strapped, you don't have so much money to be spent on legal, but you can at least do an initial consulting in the kind of early phase of your project with some legal professionals that can at least make you understand what is the kind of regulatory framework, the regulatory environment that surround your business model and your activities. Let's go back a bit to what is a regulatory strategy really like in practice. And let's say, for instance, that you operate a DeFi platform, which is one of the case studies that we will analyze later on. So a regulatory strategy there would really be about identifying the key elements and functions of your DeFi protocol, assess if the performance of these functions is or not subject to regulations in the most significant jurisdictions in which you operate. And then, based on that, to understand if you need to get licensed, if not, what kind of license you need to get, how long will it take, what are the requirements to get licensed, and then also, as I was saying before, you should evaluate basically how to align the development and release of the functions of your platform with the regulatory strategy. So again, you could come up with a version 1.0 that does not require any authorization or license and go to market and launch it and start generating revenues, and then do the process to get authorized, basically, and to release a second version of the platform with more functions, more stuff on it that indeed requires a certain authorization, but you will have that authorization because you started the process in due course. Another kind of approach here is to base it on the jurisdiction, and we will come to this basically in the next slides. So I will leave the jurisdiction part to later on, because it really matters with the corporate structure. So, point here is, what is the right corporate structure? And this goes a lot with the regulatory strategy, because being based in a jurisdiction or in another makes a significant difference in terms of what are the legal risks involved, what are the applicable regulations, and so on. Even though crypto projects, they often operate at an international level and they face kind of cross-jurisdiction challenges, still, being based in a jurisdiction or in another makes a lot of difference. Let's quickly go to the next slide and then we'll come back, because I want to continue on this and link it to what we were saying about the regulatory strategy earlier. So, in the example I was making, one approach could be to kind of like decide that you want to be based in a jurisdiction, assess what functions of your platform are regulated in that jurisdiction and what not, come up with the first version that is unregulated, and then approach a regulator, do the process, get authorization, release the second version. There is another version to the kind of like same strategy, and it's based on jurisdiction. So you could start your business and operate in a jurisdiction that is more easy to comply with, is more crypto friendly, is less regulated, and you launch from there, and then you can move to a jurisdiction that is more regulated, more compliant, more reputable. But before moving to the second one, you actually verify, if possible, directly with the local regulator, that your activities are compliant with respect to the laws of that regulation. And this is something very beneficial, because the point is that you approach the regulator of the second jurisdiction and you kind of work with them in order to get a ruling, or at least a very good understanding of how the regulation for your platform will work in the second jurisdiction. And the point is, if you cannot achieve a positive result, if you do not get this clarity, or if you get negative feedback from the regulator, you will simply not move there. You may identify another jurisdiction, or you may remain in the jurisdiction which you set up the project in the first place. However, you will not have to stop your business. You will not have to halt your operations. Conversely, if you really start in one jurisdiction and you base your regulatory strategy about being compliant with the laws of that jurisdiction, and you do all the process and you receive a negative feedback there, it is kind of a problem, because you may need to stop your activities, which is, of course, kind of like the worst possible outcomes, even for your lawyers. So, again, just to come back to the regulatory strategy takes into consideration multiple different things. That choosing the right jurisdiction is really a part of it. Now, let's go back to choosing the right corporate structure, which has also something to do with the jurisdiction, but not only. Why? Well, the corporate structure, in the first place, it's about what kind of entity you want to be. A lot of entities in the crypto space are foundations, we are talking about Ethereum Foundation, Cardano Foundation, Tesla's Foundation, Web3 Foundation, which is the one of Polkadot, and many others. It is a model that is very interesting. It works in the first place, we can say, in particular here in Switzerland. And it's based on the fact that the stakeholders of that organization have their stake represented by the token issued by the foundation. So a foundation is an entity that has no shares, is an entity that is basically solely related to a certain statutory purpose that is written in the bylaws. And whoever is the director of that foundation, whoever is the management of that foundation, their activities needs to adhere to that statutory purpose. And through the tokens, you can also implement a certain governance or decentralized governance that will have an impact also on how this foundation works. I think crypto foundation are a very nice solution for crypto projects and also very innovative. They kind of really represent, from a legal point of view, the innovation that comes with this model of tokens being an instrument for governance, but also for, let's say, the usage of utilities that are provided by a certain digital ecosystem. So, foundations. Another very common type of entity is simply a business company. So, company limited by shares or limited liability company, depends on the jurisdiction, the naming, and also depends on the type of structure. Of course, this is kind of the easiest to be set up. It's less expensive than setting up a foundation. It's also less complicated than setting up a foundation. Why you should do it, why you should not? Well, why you should do it, I think it's pretty obvious, because everybody needs a legal entity for a project, and we will come to that as well. And this one is a simple one to create. In particular, if you go in offshore jurisdictions, that's kind of easy to create. However, when you create a business company, the business company has shareholders. And it's very important not to create a conflict between the interests of the shareholders and the interests of the tokens. Let me give you a very clear example here. If you do a token raise and you raise 10 million and your project starts operating and it goes well, you produce revenues and so on, at some point you may say, okay, I have good treasury here. I could invest my treasury to develop new functions of my platform, to improve it, to expand the utilities of my token. And by doing this, I'm quite confident that the value of the token will increase. And so you are spending that money to create a benefit for the token owners. Now, if you have some shareholders that are more interested in the value of their shares than of their tokens, or maybe they don't even have tokens, they will tell you, well, I'm not so interested in you creating value for the token holders. I'm more interested in maybe A, getting a dividend. So give me some of these revenues that we are generating. Or B, increase just enterprise value. Now, increasing the enterprise value and increasing the functions of the platform and the functions of your token may go along, but they may also not. So it is very delicate for an organization to have different stakeholders that have their interests represented by different instruments, tokens and shares. This is something to be really taken into consideration. You should also take into consideration that in a lot of Web3 projects, there are complex corporate structures. Complex, that does not mean like it's a difficult corporate structure. It just means that it's composed by different entities. So you may have a foundation that is the one that issues the token and the one that also kind of like runs your platform, or at least it's the center of your digital ecosystem. But you may also have some other entities that are, for instance, technology service providers or kind of other sort of companies that are part of your ecosystem, but have different roles. This is often done when you want to fundraise with both equity and tokens, but you want to prevent any possible conflict between the two. So maybe let's say again, DeFi, which is the case study we will analyze later, what you could do is that you have a technological entity, like a business company, in which the co-founders have their shares and raises an equity. And that entity is the one that hires people, employs them, that has the office, that really pays the bills, and owns all the intellectual property related to that DeFi platform. And then this intellectual property can be licensed perpetually to a foundation that is the head of your digital ecosystem. And this foundation is the one dedicated to the real crypto activity, so to running the platform, to issuing the tokens, fundraising via the token. And this way, you keep the interest separated, because the token holders have a relation with the foundation, and the foundation has its own purpose, its own treasury, its own activities. And the shareholders have an interest in the business company, and also the business company has its own activities, its own intellectual property, its own revenues, and so on. So this is a quite common one. There are many other kind of combinations that can be created for the setup of Web3 projects. Another point here is, how does the incorporation work? What are the ongoing compliance requirements and so on? So here, look, it really depends on the jurisdiction, but we can say that all incorporation, they involve drafting a decent amount of legal documents that should be drafted by a professional in order to get things right. Involves, of course, identifying with the different roles within this entity, the corporate governance. So, who will be the CEO? Will there be a board? Will there be not a board? What are the key functions inside our company, and who will take responsibility for those? And also, who will be the shareholders, with what percentage? Like, all these things is very important that the founders of a project, they kind of figure out by themselves, even before going to a lawyer, so that they have very clear ideas, and that then they kind of like get this started. Of course, you can also reach out for advice and the structure, but also on the kind of like internal framework and the corporate governance. But important thing is that you reach out to a lawyer to get legal advice when the decisions are kind of made internally, and there is agreement between the founders about what are you going to establish, how it will work, and who will have what, both in terms of shares and in terms of roles. And then, how does it really work? Well, basically, again, you have to prepare a set of legal documents that includes usually the articles of incorporation, the bylaws, and some other forms that you will need to submit to the commercial register of the country in which you are going to incorporate. And then, usually, depending on the jurisdiction, it takes between 2 and 4 weeks. And then you have your company and you can start operating. Then what are the ongoing compliance requirements? Well, the most important one is about accounting. And this is something that is often neglected in the crypto space, also because it's difficult to account in crypto. We know it. There are a few firms that are specialized in doing accounting for crypto projects. We warmly invite our clients to reach out to one of those. It's very important that you get your accounting right, regardless of the fact that maybe you are based in an offshore jurisdiction in which there are not so many taxes to pay. Still, keeping the accounting is a requirement basically everywhere in the world. So keep it right, because if in the future some problems will come up, whether your project basically goes to bankrupt, or you want to fundraise more, or whatever kind of reason, you need to have proper accounting, because accounting is the history of company. Now, we come to the right jurisdiction. Look, we have anticipated a bit this topic. Let's just dive into the last 3 bullet points. So, onshore versus offshore. This is a big topic. In crypto space, a lot of companies are set up offshore. We also set some up offshore. There's nothing particularly bad about it. There is nothing illegal about it. Of course, if done in the right way. being based in an offshore jurisdiction can often provide a lot of advantages in terms of simplicity, easy to comply with the regulations because regulations are simple, not so much of a tax burden. However, you should take into consideration that you need to pay taxes where you are resident, that you need to have economic substance in whatever is the jurisdiction in which you incorporate, and that if you incorporate in one jurisdiction, but then the real center of the activities of your company is in another jurisdiction, then this other jurisdiction may claim that that entity should pay its taxes where the actual business really takes place. So these are aspects to be taken into consideration when you are considering to set up an offshore company. There are also some positive aspects, as I was saying, for instance, when it comes to the issuance of a token and fundraising to utility tokens. Doing it in Europe, for instance, onshore, it's not that bad as doing it in the US, where you are almost 99% sure you will breach security law. However, even in Europe is not super easy. In particular, the tax side is kind of uncertain. If you need to pay VAT, when do you need to pay VAT on the tokens, or if the proceeds from the token sale are part of your revenues, if they're not, like it's a bit complex. So sometimes setting up the token entity offshore is beneficial for a lot of different reasons, in terms also of reducing the uncertainty related to a certain project. And then we can go a bit more in depth for Switzerland and for Dubai. Well, Switzerland is the jurisdiction in which we are based. I think most people know that Switzerland is a very crypto-friendly jurisdiction. It is, indeed. Why? Well, for various different reasons, because Ethereum came here back in the day, because we have an ecosystem of professionals, of banks, of different institutions that work with crypto. It's not a silo as it is in some other places. But most of all, and this is really a key point, in Switzerland, you can kind of clear your uncertainty. Because in Switzerland, you can speak with FINMA, which is the financial regulator, and you can speak with the tax authority in order to get clarity about how their rules will apply to the problem. So if you have a DeFi platform, let's use this as an example, you can reach out to FINMA, explain them how your platform works, do a legal assessment of how it should be regulated, and then get them to confirm this assessment. And so you have 100% clarity over the rules that apply to the platform. Same for taxes. You, again, want to fundraise through the issuance of a token, you need to figure out how to pay taxes on these. Well, before doing the token offering, you can reach out to the tax authority, find with them an agreement, and then you simply have to stick to it. But there is no uncertainty, there is no doubt, there is no fear that someone will come back to you and tell you didn't do this, you didn't do that, you're not compliant. This is very beneficial for entrepreneurs. This is even more beneficial for investors, because investors, in particular VCs and other funds, they want to be safe in terms of compliance and in terms of all, let's say, the legal side of their investment. And therefore, having this sort of clarity from the beginning kind of facilitates them and, of course, makes your business more appealing to them for investment. Let's also focus a bit on Dubai, because there is a lot of hype around Dubai. Dubai is an interesting place. They are trying hard to become a center, a hub for crypto, blockchain, and Web3. And they definitely succeeded on a certain level. They created a specific regulator that is only with crypto. It's called VARA, Virtual Assets Regulatory Authority. It's a nice idea. However, it's something that will take some time before being really implemented in the right way. Why? Simply because it's a small authority, there are a lot of demands. If you want to get regulated in Dubai, it takes quite a long time. So, yes, it is a good jurisdiction, At the same time, it's not so easy as someone may think to comply with the rules there. And most importantly, there are rules. Like, there is a misconception about the fact that in Dubai you can do a bit whatever you want. That's really not the case. You should be careful with what you do in Dubai. Also, maybe kind of one warning, Dubai is also a great place for people that have not so good intentions. So be careful when you deal with the place. I'm not saying everybody is bad. Far from that. I think there are a lot of people that do business in a positive way, but there are also some bad actors, and you should be careful with those. And now we come a bit towards the end of this webinar, and we go into the more practical side. So, having said all these, the fact that you need to create your own regulatory strategy, that you need to get the right corporate structure, that you need to create that corporate structure in the right jurisdiction or jurisdictions, how to do all this, how to define what we call the legal or all the steps that you need to perform, basically, in order to be okay on the legal side. Well, it really needs to start with what are the project's goals and timeline. So what is the roadmap of your project in the first place? When do you want to launch? When do you want to launch your token? When is the TG? When are you going to launch your platform? What functions will be operational in the first place? What functions will come later down the line? Like, you need to have very much clarity over your own timeline and roadmap. And then you will build a legal roadmap on the basis of that. Of course, the legal roadmap can influence the main one. Sometimes it can delay. Of course, we do our best not to do that, but sometimes it happens. But the important thing is that you do not allow the legal roadmap to dictate the formal roadmap. No, it is the legal roadmap that needs to align with your main roadmap, as long as this is reasonable. So let's start from that. Let's start from establishing your goals and the timeline. And then basically the first question should be always when you should incorporate. What can you do to coach up if you started the process today? Why this is done? Well, because incorporation is really the start of a business. Like, when a business passes from an idea, from a group of people, the founders that are kind of discussing between themselves, should we do this, should we not, and they really want to try, they should incorporate. In particular, please consider that incorporate for us also means create a limited liability company. And I want to stress limited liability. You should not be personally liable for your business. The idea of limited liability companies is really this. It's the fact that the company is a separate legal person that answers all his obligations with his own treasury, which is separate from your personal treasury. So it's important to operate with an incorporated legal entity in order to avoid personal liabilities. That's really, really important. What can you do to catch up if you started the process too late? Many different things. But first, if you know or suspect that you are a bit late, that you started maybe fundraising, you started accepting some investors and so on, and you don't have a legal entity, reach out to a lawyer, get some advice, incorporate, fix the situation. Ignoring the problem will not solve it, will just make it bigger. And then, of course, step 3, once you have at least incorporated or you are kind of close to that, understand the regulatory strategy. Look, I think a lot of people get this a bit like the wrong way. It's not hyper complicated. In the first place, a project founder or the founder should be able, at least with kind of like little legal knowledge and some online research, to understand what's the regulatory context around their initiative. Once you get that, you will understand by yourself how urgent it is for you to speak with some legal professionals and how urgent it is for you to establish a clear regulatory strategy, and also what are the questions that you have about that. Because I think that a lot of people can actually come up with at least a basic idea of what the regulatory strategy for their project can be. And so, and we come to the last point, yes, get some professional advice. This honestly is something, it's clear that I'm biased here, guys. This is my job, like, I do this. So when I say get professional advice, I could even say come to me. No, I don't have the resources to assist everybody, but I'm not saying this to defend my category, really. Like, the point is, it is in your interest to get a professional to tell you what needs to be done. In the first place, because everybody has their own job and everybody has a specific knowledge that can help someone else. Okay, so if you need to get logo, you go to a designer. If you need to get PR, you go to a copywriter. If you need to get legal advice, go to a lawyer. If you have pain in your leg, go to a doctor. Like, it's really that. Don't fear legal advice because of the cost, because of whatever. Like, I think that there are a lot of solutions that can come up, but I have seen some projects in the past kind of like avoiding or postponing getting professional advice on the legal side, and this created a lot of problems to them. Sometimes they were able to kind of like go back to a positive situation, sometimes not. And I think that's pretty much it in terms of the kind of like general knowledge, and we can go to the case study. So I think we said a decent amount of stuff about the DeFi platform, which is our first case study. What else can we say? Well, DeFi is one of the most innovative and challenging areas from a regulatory perspective. So it is difficult, honestly, to understand the regulatory framework that should surround the DeFi platform. In that case, you need to get not only professional advice, but good professional advice, like work with lawyers that actually have an understanding and a track record that can show they know what they're talking about. Why is it so complicated? Well, because DeFi has to do with financial services, and you really need to check with your lawyers if financial regulations are applicable to your activities or not, and to what extent they may be applicable, to what extent they may not be applicable. And it's very important to be compliant with financial regulations, because there are huge fines and even in some cases some kind of criminal liabilities related to not being compliant with financial laws. Why? Because you deal with money of someone else. Now, this was the initial disclaimer, then we can come to the good part. So, what is the point of DeFi? Why is DeFi unregulated, or at least some DeFi platforms are unregulated? Well, because the real point here is that in a traditional trading venue, it works that there is a centralized actor that basically does transactions with everyone. If you want to buy, if you want to sell, and so on. In DeFi, this doesn't happen. What happens actually is that there are a set of smart contracts that regulate how people do transactions between themselves. And who is the operator of the DeFi platform does not actually have control over the funds that people exchange. They don't custody those funds. They have no real control of the transactions. They just create the framework for these transactions to happen between the users of their platform. And this is very different from trading venues that are conceived within financial regulations. And therefore, these regulations, if the platform itself is created in, let's say, the correct way, are not applicable to DeFi. Now, what are the characteristics that can make a DeFi platform more centralized, and therefore those activities should fall within the scope of regulation? So, the operability of the smart contracts is an important factor to be taken into consideration. A real decentralized platform should not have operable smart contracts, or if they do have a upgrade of smart contracts, then it should be done in a way in which there is a kind of like consensus mechanism between the users of the platform in order to upgrade the smart contracts or not. If there is a kind of like platform operator that can modify the smart contracts whenever they want, then this is not really centralized. Another important aspect is the open source part. So the smart contracts should be open source. And theoretically, what should happen in a real DeFi platform is that the platform operator should just provide an interface that facilitates the interaction with a certain set of smart contracts. And therefore, if you're a normal user, you would use this kind of like gateway to access this infrastructure of smart contracts and carry out your transaction in this way. However, if you are a very tech-savvy and expert user, you should be able to interact directly with those smart contracts without, of course, passing through the interface. And this makes a very good case for a platform being decentralized. Having said all this, when it comes to DeFi, I would say that some useful tips that can be considered are related to basically where to incorporate. Often offshore is still better for DeFi because there are less risks and it's once complied with local regulations. And then maybe some, but you can also stay onshore. It depends on the jurisdiction. For instance, here in Switzerland is a good one because, again, you can do what we were saying before. You can go to the regulator and get clarity from them about the legal side of your project, and you could agree with them if you need or don't need a license. Second case study, DAOs. DAOs are something we didn't speak about during this webinar. It's a very interesting and innovative type of human construct of organization. And there are more and more jurisdictions actually coming up with regulations for DAOs. So the Marshall Islands, I think we have a slide over here. That is disconnected. I'm reconnecting. Yeah. So DAOs. As I was saying, there are numerous jurisdictions that are coming up with laws and regulations related to DAOs. For instance, Marshall Island has the Decentralized Autonomous Organization Act that allows you to really incorporate what they call a DAO LLC. There's also Wyoming, Utah, I think, came up with some of those. But also, you can use traditional legal entities like foundations, associations to create a DAO. What is DAO? A DAO is a token-based organization. It's an organization in which the governance is based on the token. In various different ways. It could be that one token represents one vote. It could be that you use a square root voting in order to kind of like mitigate the impact of whales mechanism. But in any case, the DAO is related to an organization. Like every DAO needs to be an organization that is based on a token. Now, what does it actually mean to be a DAO? Well, this is kind of a philosophical discussion. Is every DAO really decentralized? Is every DAO really autonomous? I think everybody can agree that a DAO is an organization. At least this last word should not be a source of conflict, but regarding decentralization and autonomy, or not, that's a bit more difficult. I think my perspective, at least, that the important is not that a DAO is what it wants to be at the very beginning, but that there is a roadmap in order to achieve full decentralization. Decentralization is not easy. And I think we are really in a kind of like laboratory phase when it comes to DAOs in which everybody that is trying to set up one or to operate one is kind of understanding how it works and what are the challenges and so on. And I think in a few years then we will have some better rules. I think if I have to look at the DAOs we work with, the most common problems are the involvement of token holders, the fact that only a few token holders actually vote on the resolutions, how to keep people engaged, how to keep them interested in what's going on in DAO, how to make them feel that the DAO treasury is also their treasury, that they should defend it and not kind of like put forward proposals on how to better spend the money that the DAO owns, and so on and so forth. So the DAO is something that is challenging from a regulatory perspective, but actually I think not that much. I think that there are various options to set up a DAO in a compliant way and also in the right way. I think that the most challenging part is actually to understand what kind of DAO you want to create and how should this DAO work. What are really the rules? Because then we can take these rules and translate it into the bylaws and all the legal documents, but we need to have a good base to work on. For today, that's pretty much it. These are, of course, our contacts. You can reach out if you have a project and if you have any further question and you need our assistance. We are here, or come to meet us at the Decentral House here in Geneva. It's our Web3 hub. It's really dedicated to people in the space. We host a lot of events, and also we are a co-working space if you want to come and work from here. Thank you very much, and see you at the next masterclass.